India has witnessed a tremendous rise in cyber related crimes. The recent tragic episodes of boys and girls locker room made us realize that many odds are on the way while dealing with the police for cybercrimes. The current uses of Pegasus software is bluntly violating our fundamental rights and tracking the uses of its altogether another difficulty. In the race between the strengthening of cyber related laws and rapidly changing technological misuse, the former is leading the other rampant and is way far ahead. From the journey of Shreya Singles to K.S. Puttaparthi Swamy case, the court has recognized the important principles of privacy and freedom of speech and dealing with the cyber related offences with rigid hands. In this video, we are going to learn the laws and addresses the question whether the current laws and the penalties mentioned thereof are able to halt or limit the growth of cyber offences. The author intends to draw the distinction between the court's activism and legislative competence in dealing with cybercrime. While focusing the important aspects of cyber law and while considering the provisions of cyber law, there are a few important sections which provide you the complete protection and prevent cybercrime. The first section which I would like to explain here is section 65, tampering with computer source documents. Whoever knowingly or intentionally conceal, destroy or alters or intentionally or knowingly causes another to conceal, destroy or alter any computer source code used for a computer, computer program, computer system or a computer network when the computer source code is required to be kept or maintained by law for the time being in force shall be punishable with imprisonment up to 3 years or with fine which may extend up to 2 lakh rupees or with both. For the purpose of this section, computer source code means the listing of programs, computer commands, design and layout, program analysis of computer resources in any form. Herein section 482 CRPC petition was called and the court in the case of Syed Asafuddin and others versus the state of Andhra Pradesh held that the submission that as there is no law which requires a computer source code to be maintained, an offence cannot be made out is devoid of any merit. The disjunctive word or is used by the legislature between the phrase where the computer source code is required to be kept and the other phrase maintained by law for the time being in force and therefore both the situation are different. Thus, on a prima facie look of the section it appears to be restrictive one form what the court has given the wider and broader interpretation. Now, understand what section 66 read with 43A of IT Act says about. Section 66 computer related offences. If any person dishonestly or fraudulently does any act refer to in section 43, he shall be punishable with imprisonment for a term which may extend to 3 years or with a fine which may extend to 5 lakh rupees or with both. The interpretation of words fraudulently and dishonestly are to be derived from the Indian Penal Code 1860. The section 43 which is referred to section 66 deals penalty and compensation for damage to computer and computer system and other. It states that if a person without permission of the owner or any other person who is in charge of computer and computer system or computer network access or seizes access to such computer, computer system or computer network or computer resource. The second, the downloads, copies or extracts any data, computer database or information from such computer, computer system, computer network including information or data held or stored in any removable storage medium. Introduce or cause to be introduce any computer contaminant or computer virus into any computer, computer system or computer network. Damage or cause to be damage any computer, computer system, computer network, data, computer database or any other program residing in such computer, computer system and computer network. E. Disrupts or causes disruption of any computer, computer system or computer network. F. Denies or causes the denial of access to any person authorized to access any computer, computer system or computer network by any means. Damages by way of compensation to the person so affected. Now understand what section 66B says about. Punishment for dishonestly receiving stolen computer resources and communication device. Whoever dishonestly receive or retains any stolen computer resource or communication device knowing or having reasons to believe the same to be stolen computer resource or communication device shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine which may extend to rupees 1 lakh or with both. Now learn what section 66 says about. Section 66 says about punishment for identity theft. Whoever fraudulently or dishonestly make use of electronic signature, password or any other unique identification feature of any other person shall be punished with imprisonment of either description for term which may extend to 3 years and shall also be liable to fine which may extend to rupees 1 lakh. It is quite clear that when there is a stealing and use of a passwords or e-signature or any other unique identification, for example, Aadhaar of someone else with malified intent of misusing, then offence is made out. Section 66D says about punishment for cheating by personation by using computer resource. Whoever by means of any communication device or computer resource cheats by personation shall be punished with imprisonment of either description for term which may extend to 3 years and shall also be liable to fine which may extend to 1 lakh rupees. The Honorable Karnataka High Court brought an analogy in bail application wherein it was said that in a crime of this type, though all the necessary ingredients for the offence of section 468 of Indian Penal Code are present after coming into force of Information Technology Act, the essential ingredients of the offence under section 420 and 468 of Indian Penal Code are imminent in section 66D and section 66C of Information Technology Act, which are bailable. Now understand what section 66E says about punishment for violation of privacy. Whoever intentionally or knowingly capture, publish or transmit the image of private area of any person without his or her consent under circumstances violating in the privacy of that person shall be punished with imprisonment which may extend to 3 years or with fine not exceeding 2 lakh rupees or with both. Now understand what section says more about. Subclause A says about transmit means to electronic send a visual image with intent that it to be viewed by person or persons. B. Captured with respect to an image means to videotape, photograph, film or record by any means. Publishes means reproduction in the printed or electronic form and making it available for public. Under circumstances violating privacy means circumstances in which a person can have a reasonable expectation. Now understand what section 66F says about cyber terrorism. Cyber terrorism, as the name suggests, the term can be divided into two independent terms, cyber and terrorism. Both are considered the two greatest worries of the late 20th century. Both convey apprehensive about the unknown, the fear of being victimized at random, and violently ties in nicely with the suspicion and downright fear of computer technology. Section 66F, punishment for cyber terrorism. Whoever with intent to threaten the unity, integrity, security or sovereignty of India, or to strike terror in the people or any section of the people by denying or cause the denial of access to any person authorized to access computer resource, or attempting to penetrate or access computer resource without authorization or exceeding authorized access, or introducing or causing to introduce any computer contaminant, and by means of such conduct cause or is likely to cause death or injuries to person, or damage or destruction of the property, or disrupts or knowing that it is likely to cause damage or disruption of supplies or services essential to the life of the community, or adversely affect the critical information infrastructure specified under section 17. B. Knowingly or intentionally penetrates or access a computer resource without authorization or exceeding authorized access, and by means of such conduct obtains access to information, data or computer database that is restricted for reason of the security of the state or foreign relation, or any restricted information, data or computer database with the reason to believe that such information, data or computer database so obtained may be used to cause or likely to cause injury to the interests of sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offence, or to the advantage of any foreign nation, group of individual or otherwise commits the offence of cyber terrorism. Whoever commits or conspires to commit cyber terrorism shall be punishable with imprisonment, which may extend to imprisonment for life. Now focus on section 67, punishment for publishing or transmitting obscene material in electronic form. Whoever publishes or transmits or causes to be published or transmitted in electronic form any material which is lascivious or appeals to the prudent interest, or if its effect in such as to tend to deprave and corrupt person who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it, shall be punished on first conviction with imprisonment of either description for term which may extend to 3 years, and with fine which may extend to 5 lakh rupees, and in the event of second subsequent conviction with imprisonment of either description for a term which may extend to 5 years, and also with fine which may extend to 10 lakh rupees. Now understand section 67A, punishment for publishing or transmitting of material containing sexually explicit act, etc. In electronic form, whoever publishes or transmits or causes to be published or transmitted in the electronic form any material which contains sexually explicit act or conduct shall be punished on a first conviction with imprisonment of either description for a term which may extend to 5 years, and with fine which may extend to 10 lakh rupees, and in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years, and also with fine which may extend to 10 lakh rupees. Section 67B. Section 67B is used for punishment for publishing or transmitting of a material depicting children containing sexual explicit act, etc. in electronic form. The punishment under section 67A is similar to section 67B. However, there is a substantial widening of scope of the offence under section 67B because there is a child abuse and violation of the rights of a children. One important distinction and lacuna in the present position of law is that viewing, downloading and possessing in the content is not punishable unless the victim are children. While it is impractical to prosecute every person in possession of the content, exempting those who are complicit in the crime conduct from liability defeats the goal of preventing obscene content from being circulated. Section 67C, Preservation and Retention of Information by Intermediary. Intermediary shall preserve and retain such information as may be specified for such duration and in such manner and format as the central government may prescribe. Any intermediary who intentionally or knowingly contravenes the provision of subsection 1 shall be punished with an imprisonment for a term which may extend to 3 years and also be liable to fine. This section is a self-explanatory. Section 69. Section 69, which says about power to issue directions for interception or monitoring or decryption of any information through any computer resource. According to this provision, the subscriber or intermediary have a duty to provide access, facilitate and to furnish any information which the central or state government or any officer appointed by it demands. Contravention of this result in punishment prescribed under section 69(4), either imprisonment for a term which may extend to 7 years and also shall be liable to fine. The scope of the function, duties and liabilities is widened by the enactment of Information Technology Act, which coming under Procedure and Safeguards for Interception, Monitoring and Decryption of Information Rules of 2009. Section 69B. Intermediary who intentionally or knowingly contravenes the provision to authorize to monitor and collect traffic data or information through any computer resource for cyber security. This provision enables the central government to adopt agency by way of notifying the same on official gazette. The agency thereupon have power to monitor and collect traffic data or information generated, transmitted, received or stored in any computer resource. Section 71. Penalty for misrepresentation. Whoever makes any misrepresentation to or suppresses any material fact from controller or certifying authority for obtaining any license or electronic signature certificate, as the case may be, shall be punished with imprisonment for a term which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both. This section is a self-explanatory wherein it imposes penalty for misrepresenting or suppressing any material fact from controller or certifying authority. Section 72. Penalty for breach of confidentiality and privacy. Save as otherwise provided in this act or any other law for the time being in force, if any person who in pursuance of any of the powers conferred under this act, rules and regulations made thereunder, has secured access to any electronic record, book, register, correspondence, information, document or other material without the consent of the person concerned, disclose such electronic record, book, register, correspondence, information, document or other material to any other person, shall be punished with imprisonment for term which may extend to 2 years, with fine which may extend to 1 lakh rupees or with both. Section 72A. Punishment for disclosure information in breach of lawful contract. Save as otherwise provided in this act, any other law for the time being in force, any person include an intermediary who while providing service under the terms of lawful contract has secured access to any material containing personal information about another person with the intent to cause or knowing that he is likely to cause wrongful loss or wrongful gain, discloses without the consent of the person concerned or in a breach of lawful contract such material to any other person, shall be punished with imprisonment for the term which may extend to 3 years or with fine which may extend to 5 lakh rupees or with both. Section 74. Publication for fraudulent purpose. Whoever knowingly creates, publish or otherwise makes available an electronic signature certificate for any fraudulent or unlawful purpose shall be punished with the imprisonment for a term which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both. The provision is self-explanatory. One can easily relate the same with section 463 of Indian Penal Code, either for forgery as well as section 420 of Indian Penal Code, either for cheating. Section 45. Residuary penalty. Whoever contravenes any rules or regulations made under this Act, for the contravention of which no penalty has been separately provided, shall be liable to pay compensation not exceeding 25,000 rupees to the person affected by such contravention, or a penalty not exceeding 25,000 rupees. The above provision applies to those rules or regulations acting as subordinate legislation in case there is no mention of penalty for offence. The said provision does not provide penal punishment as they are under watch of widely accepted judicial principle, benefits of doubt given to accused. While considering the section which provide you protection, we also need to consider few practical hurdles during trials of Cyber and Information Technology Act related offences. It is thus noteworthy that the laws are stringent as expected to be. At the same time, it lacks to recognize newly updated methods of cybercrimes. The machinery for investigation is not strong enough. These crimes need in-depth knowledge, study and tracking skills which the police machinery is finding difficulty to cope up with. Efforts are taken by executive wing to call special cyber branches and helpline numbers of the common public. However, the same is not enough and requires more advancement. IT Rules 2020-21 and the court reaction on the same was intermediary rules capture its own limelight as it was contended by the majority of public that these rules curbs freedom of press and is a tool to regulate conduct of agencies in any direction as the government wishes to. No doubt that the government intends to curb the spread of false information or curb electronic materials that have potential to breach public policy of India. However, the proposal put forward were so ambiguous and limitations were too stringent that is alleged to have entered into the category of violation of fundamental rights of people. The same was also alleged to fall beyond scope of the Parent Act. Thank you.